This conference will now be recorded.
Okay, so welcome everybody. Happy Friday. Happy Earth Week as well. I hope you've gotten outside and done a little bit of something both for yourselves and for this beautiful world we live in. I'm really happy that Jill invited me to do this presentation for all of you. And since we are a small group today, I'm not going to mute anybody because I do want you to ask questions, tell me some concerns that you see happening with the clients that you're serving, okay? All right, so we're going to start by, I'm going to share my screen with you, and we're going to first see a short video that I love. And I'm going to take a break after that video before we start the PowerPoint to give you an opportunity to ask questions.
You know how to do that, Jill? Because I don't.
Do I have to? No, she's going to do it.
No, I know, but I'm just teasing.
Don't push it. Doing well so far.
I wouldn't know how to
downloaded this. I figured out how to do this.
Right.
Dear healthcare proxy, like if you need someone to tell the doctor what to, I just go with whatever the doctors say. I wouldn't want to bother them. They're so busy. Doctors know best, right? Dear healthcare proxy, sure, I'd be happy to. If I'm in town, check out my Instagram pics from Peru. Wish you were here.
Oh, I could never let you go. I can't even throw a plant away. As long as it's got one little green leaf, I'd be like, can't we upload her to the cloud?
Well, heck yeah. Given this a lot of thought, let me tell you what decisions you're best off going with. You never let them resuscitate. And if they even try to hook you up to one of those breathing machines, never. I got this. I totally got this. How can you even talk about this? I can't, okay? I just can't. It's not like you're gonna die. I can't talk right now.
Oh wait, did I show you that meme from iFunny? The cat and the dishwasher? Oh my gosh, okay. So the cat's like, and then he's like, wow! Oh wait, sorry, what?
Well, hon, you and I have been through so much together. Here's what we'll do. We'll sit down, get a cup of coffee, and you tell me what matters to you.
Well, it wouldn't be easy. I mean, I'd be sad, but I'd have your back.
I think that when we went through this with Mom, we really spoke for her. So I think I can do that for you. Let's talk about what you've been wanting.
So what do you think of the video?
I know who I would pick.
Who? Well,
Donna.
let me start by asking all of you, who do you identify the most with out of all those characters?
I think it was Donna.
Yeah, the same for me.
Mm-hmm.
What was it about her character?
She was willing to like have a conversation about it and really like learn the individual's wishes and seems to understand what that role would entail. Whereas the other people are like, oh, that's sad.
Aiden, how about you? Which character did you identify with?
I can't hear Aiden.
Okay, Aiden's mic is on. You might need to raise the volume.
Well, I can hear you, you and Jill fine.
Oh, Karen's joined us. Hi, Karen.
Can you hear me? Can you hear
Now
me?
we can.
Can you fix it so that you can be on video, that we can see you?
I'm trying to.
Okay. Did you
Okay.
download the app?
I didn't download the app.
I don't think she'll be able to do it if she does download the program.
Karen, what device are you on?
My laptop.
Okay, that's fine. So look in your upper right-hand corner. You're going to see some little icons. There
Okay.
should be one that looks like an old-fashioned movie camera. I need you to click on that.
Yeah, I got that on the bottom.
Okay.
Turn on camera. That's what
Yeah.
I'm doing. Download a free. Wait, hold on. Click the camera and media. Okay. Well, I could listen in the meantime, so I'll try to figure it out.
Okay, Aiden, can we hear you now?
I
No.
can't.
Your microphone isn't working even though it's on. Did you raise the volume? Okay, Aiden, you want to try using the chat feature?
Aiden, up in the right-hand corner, you see the little icons in there. Look, there's like a sort of like a little circle where it looks
It's-
like
yeah,
when
it's a speech bubble.
cartoon, you know, a bubble. That's the chat icon.
Is Aiden.
Okay, so he says Donna was his choice as well.
Okay. Now, can you look at your family, your extended family, or your group of friends and see some of the other characters in this video in those people?
Oh, definitely.
Yeah. How about in your clients? Do you see any of the characteristics of the people in the video other than Donna in the clients that you serve? Who do you think is the character or the attribute you're going to see most often when new clients contact you?
Forget their names now.
You could just describe their approach.
The one guy with the red hair. Not so much him. I feel like he's more like millennial, like our generation. If you were to ask someone of that, but I feel like more our clients are mainly older, like adult children. So the one, not Donna, but the other one she circled. I forget her name.
So there was the lady that suggested they have coffee and sit and talk. There was the young woman that was washing dishes. And then there was her brother.
And what about the older guy
At the end or in the beginning?
in the beginning?
So the first person was the friend who's traveling and basically says to her, unless you can reach me on Instagram, you know, I won't be able to communicate with you. Then there was the friend sitting at the park outside who's afraid to even let go of a dying plant.
So, I mean, we have that, Karen has a case like this now. She has a case where there's a very dear friend who, out of the goodness of her heart, took on the role as her healthcare surrogate and her durable power of attorney, you know, her attorney in fact. Okay, the son, has two sons, and neither son could step up and manage anything about this woman's life. But now the friend has her own health issues, and she's likely going to move out of state to live near her children. You know, one of the usual profiles. Okay, now the son sort of got pushed into the situation, and everything with him is on mañana time, all the time, right? And how he manages, you know, his wife's, I mean, his mother's life. You know, that it doesn't seem like there's any big sense of urgency, right? And he lives out of state. So, you know, it's not like, okay, reach me on Instagram, but, you know, let's say if Karen reaches out to him 4 times, right, over a period of time, okay, by the 5th time, we get lucky, we back out. So, you know, it runs the gamut. I feel like we've had every one of these. And
Yeah, in a different way.
the significance of the document, right? What it means to make someone, to give someone that authority. I think we all deal with that. Wouldn't you say, everybody, that's fair to say? We deal with people not understanding the authority they're being given.
Absolutely.
Absolutely, yeah.
Hey, Aiden, your mic is working
You can
now.
hear me now? Okay, good. I've been messing with it, so good.
There's a little bit of interference. I'm not sure what it's due to.
Okay.
But I'm glad you're able to speak up now.
How about now?
Yeah, that's good. So
Okay.
I do agree with you. You know, in my elder law practice, I definitely have seen all of those different personalities. But what I love about the video, and that's why I chose to start with it, is I think it gets us to laugh. It's like an icebreaker about a subject that can, for some people, be very uncomfortable to talk about. And it's extremely uncomfortable for them to talk about it. They're not going to take any steps to do something about it, which to me is the real shame. And so I will, when we're done today, I will send you all the link to this. And I hope that you will share it, you know, with professional colleagues, with family members, with clients, because my hope is that this organization that put this together really was encouraging people to have that conversation, to be able to face whatever their fear is and move through it and past it. So I hope you enjoyed it.
I did. It made me laugh.
Good. Is there anything anybody would like to ask or share as we're moving into the PowerPoint?
Nope.
Okay.
Not yet.
So when Jill and Amy saw this webinar last week, it was in celebration of what's called National Healthcare Decisions Day, which is always in the month of April. And my goal in hosting the webinar was to encourage people, whether they're professionals or consumers, to talk about them. And I really thought that no other time was more timely than now, given the pandemic that we're all living in not just the US, but around the globe. And if anything, I'm hoping that it's going to help to wake people up to realize that there is no magic age that you turn when you should start to think about advance directives. And if you think back to March, probably around March 13th, when our governor decided to shut down the state of Florida, in the first week of the reports, we were hearing that a lot of older individuals or people with compromised immune systems were being very badly affected by the COVID virus. Many people were on ventilators, many people passed, but we weren't hearing stories about younger individuals until the week started going on. And then we were hearing stories about young children, people in their 20s. And so to me, this is a prime example. While I hope to God this never happens again, it is an example that life happens and we've got to plan ahead and have these advance directives in place. So what I think is important to look at is what level of competence is required in order for a client to make an advance directive. Now, in the law, there are certain levels of competency that are required, and the main difference is that with healthcare directives, it's a lower threshold of competence. With documents like a will, a power of attorney, a trust, these are documents where we're giving financial decision-making authority. A person has to have a higher level of capacity. So we would want them to be oriented ×3, for example. We need them to be able to tell us who the members of the family are. We need them to be able to identify what their assets were, where are they located, what are they valued at. Because it shows that higher level of understanding. But with healthcare directive, what we're looking for is an understanding of choices, of being able to make the informed decision to name a surrogate, to make a living will, for example. Give me one second. Great, I was just hearing background noise. Mute everybody. Bear with me. Are you hearing me here, Lynn?
I hear the feedback and it is making it difficult to hear you.
Feedback, that's
There's an echo.
Would it help if we all turn off our mic until we need to
You
talk?
would mute yourselves. Let's see if that gets better.
You want me to mute my mic, you're saying?
Yes, I'm going to ask everybody to mute their microphone. Okay. Thank you. All right. So one of the challenging issues that will sometimes arise is how do you help people who never made a written advance directive? Their family is now coming to you and they need direction. They need guidance. So I want to lay out for you 3 possible options that will help you get them through that challenging time. The first thing you're going to want to consider is what is called Florida's healthcare proxy law. Now, this is a statute that provides a list of individuals in a particular order that a healthcare provider can select and say, you're going to be the healthcare proxy for Mrs. Jones. The nice thing about the healthcare proxy statute is that if it is acceptable to the facility, to the healthcare provider, it means that we don't have to tell that family they have to go to court and do a legal guardianship proceeding for their loved one. And that's going to save them time. It's going to save them expense. It's going to save them the loss of privacy that happens when we file a guardianship and it becomes a public record that you can view online at home on your computer. So let's talk about the order of the people listed in this statute. So it is essentially, after the first 2 categories, it essentially goes in order of the closest of kin in the bloodline. So first it's going to look to see, is there a spouse who could be appointed the proxy? If we have no spouse, then the next order, the next category is, does this person have any children? If they don't have children, then they're going to look to siblings or parents, and then we're going to move further and further away to cousins. Now, a number of years ago, there was an issue about people who had no family. They couldn't find family, and it was very challenging. So the legislature ended up adding a new category at the very end, which could be somebody who is a friend or somebody who knows the person and is willing to act on their behalf. They also added to that definition that the proxy could be a licensed social worker. So this enables people in that position where maybe they never married or the spouse died, they never had children, their closest of kin have died off, or perhaps they cannot be located either in the US or in other countries, it now allows that friend or the neighbor or the social worker. And for the social worker category, it doesn't mean you have to have had a prior relationship with the individual. So any of those three people could agree to serve as the healthcare proxy. Now, the way the statute works is if there are multiple individuals in a category, then all of them are the proxy, and they must agree by majority as to the decision that's going to be made. So this is where there is the potential for an issue to arise if people cannot agree on the course of action, the course of treatment to be taken for the patient. So if anything, you can use this as an educational tool with your clients to say, well, this is a fallback option. It's not one we would recommend, because if you have division within the family and everybody cannot agree on the course of action, it's going to be problematic. And then you are going to have to go and do the guardianship. So if anything, this is a great plug for why people do need to designate a healthcare surrogate in writing. So they avoid that disharmony in the family. They avoid a physician or a hospital being put in the position of not choosing and just saying, go file for an emergency guardianship. So that's option one. Option two is if we don't have, let's say, a living will. We don't know what did this person ever want. Had they thought about the issues? You can suggest that the proxy, and this can be used even for a surrogate, consult with a medical ethics committee. And I've used this several times in the past when we have an individual who's in a persistent vegetative state and there's no medical written advance directive. We have no idea what their thoughts were on the subject. We don't know if any religious beliefs played a role in what they would have wanted. So we look for what is the closest hospital to where the patient is located, and we see if they have a medical ethics committee at the hospital. And then we approach them and we request the consultation. We provide access to the patient's medical records so that it can be reviewed. And then the person who is either the proxy, the healthcare surrogate, or in some cases we've had it be a guardian appointed by the court, the guardian will go and do an in-person consultation with the committee. Now, the committee is required to have several different types of individuals sit on the committee. So there's going to be a medical professional, there's going to be a member of the clergy present, there's going to be somebody from the legal field, could also include risk management from the hospital. Many times I've also had somebody who has a palliative care or a hospice background sit on the committee. And after they all review the patient's records, they will share, based upon their different disciplines, their recommendations and the pros and the cons that could be considered if a certain decision for treatment or no treatment is made by the decision maker. So always keep this in your toolbox. This is something that may come up in the future that could be very helpful for you and the clients that you're serving. Now, if we don't have a designated surrogate, and if the proxy is not going to work, and why would it not work? Well, there's a couple of reasons. Number one, depending on a procedure that needs to be done, a hospital may not be comfortable having the proxy give that permission. And I'll give you an example. Years ago, I had one of a set of twin daughters come to me to discuss what was happening with her father. She was noticing a complete change in his behavior. He was not taking care of his hygiene. He was not showering. He was not shaving. It was very noticeable to her when she was visiting with him. The behavior was erratic. He was not eating consistently. He was not necessarily shopping for food. Her suspicion was that there was a brain tumor because he had had one years prior. And she said the behavior was very similar to the prior experience. She couldn't get him to go to a doctor. At that time, she couldn't get a doctor who was willing to go to the house. So we were exploring the proxy versus a guardianship. Now, she was able to get him into the hospital, and they did run tests, and I believe it was the MRI that showed the tumor had reoccurred in the brain. So the hospital surgeons were recommending a surgery. I then communicated with risk management at the hospital, gave them a copy of Florida's healthcare proxy statute, and requested that because he was not married, that the twin adult daughters be recognized as the proxy to authorize the surgery. Because they felt this was an invasive surgery, they wouldn't acknowledge the proxy statute. And they requested that we go and file an emergency temporary guardianship and get a court order allowing them to authorize the brain surgery, which we ended up doing. So I'm sharing that with you as an example of a time when the proxy might not be honored by a hospital or a facility. The other thing we talked about a few minutes ago when it might not be honored is if you have a split among the co-proxy decision makers and they can't agree. In that situation, I would fully expect a hospital or a facility to say, we don't want to be in a position of potentially being sued. If we listen to one over the other, go to court and get a guardianship. So if those two first options don't work, we are going to need to go to court and do a guardianship for medical decision making. The basis for getting in on an emergency time frame is very limited. So only if you see that a client is either self-neglected or they're being neglected by their caregiver, and there's enough evidence, or we'd have you to testify that this person's health and life is in imminent danger or lack of safety, that's the limited circumstance under which we can get into court and ask for an emergency guardianship for medical decision making. Otherwise, if it doesn't fall within that emergency category, we are looking at a normal time frame. And normal means we're not going to get a hearing for about 4 weeks from when we file the papers. I'll share with you a story, a case that I'm handling right now. I had consulted with an adult child of a woman who's a hoarder and who probably has significant cognitive impairment. He first consulted with me 2 years ago. He showed me pictures of what his mother's house looked like. He showed me documentation of how Adult Protective Services had done an investigation, and she had been placed in an ALF for a short period of time, but then returned back home. Based on the facts, I recommended to him a guardianship at that point in time. He did nothing, and back in March of this year, he contacted me again and said, okay, I'm ready to do this. Now, this was about 2.5 weeks before we started hearing reports that COVID had come into the US. We quickly got the guardianship documents filed with the court. They assign a 3-person medical committee to go out and see the person, and they assign an attorney to represent the individual. So all of that was put in place. And then March 13th hit. And at that point, the courts closed in Florida. The examining committee was no longer permitted, it was no longer safe for them to go out and assess the mother. So we have had that case on hold, And we've been doing our best working with the adult son that we represent to keep things as stable and as safe as possible. Fortunately or unfortunately, last week, one of the neighbors who cares about the mother noticed that she had not been out of the house to water her plants in several days, and they called the police. When she did not answer the door, they broke down the door and they found her, and EMS came and took her to a hospital. She needed emergency surgery. She had internal issues going on. Thank goodness for that neighbor, it probably saved her life. And they did the surgery, she came through it. The surgeon is ordering rehab, so she is now in a rehab facility. But unfortunately, with the timing of all this, until it's considered safe, the examining committee cannot go out and see her. So I'm going to try during our discussion to share different real life experiences with you so that you can share those with your clients when you sense that they are hesitant, they're not going to take the next step forward. Hopefully they'll learn from somebody else's experience, because waiting is not the answer. And you may just have to counsel people through whatever their fear issue is. For some, it's that the parent is going to be so angry with them that they'll cut off all communication, or the parent will retaliate, or the parent will not forgive the child and maybe cut that adult child out of their estate plan. You're going to have to ask people what their fear is in order to be able to help them. But guardianship, when it is necessary, we really need to proceed as soon as possible with it. So I don't know if anybody has ever had this situation before, where maybe you observe that the healthcare surrogate or the proxy is making decisions that you feel is opposite what the advance directive says. Now, usually this would be in regard to a living will. So maybe there's been that terminal diagnosis made, or the diagnosis of the patient being in a persistent vegetative state or end-stage condition, and you read the living will and it says no artificial nutrition, no artificial hydration, but the surrogate just instructed the physician to do the PEG or do the IV. What do? Well, again, we do have a legal process for this in Florida, and it involves filing an emergency petition with the court in the county where the patient is located. And we ask the court for what's called expedited judicial intervention. So we have to allege enough facts about the living will, about the patient's condition, about what the surrogate is doing that appears to be contrary to the expressed preferences of the patient. And Jill asked me a great question on last week's webinar, which is who would testify? We do need medical professionals to testify. It might be you, it might be the doctor, it might be a risk manager representative from the hospital. Now, before we get to the point of filing the petition, I do recommend trying to have a conversation with whoever the surrogate or the proxy is. And if need be, then bring it up to the level of the risk manager at the facility. It may be that you're giving them the opportunity to do the right thing and correct whatever is improperly being done at the time before having to bring it to the attention of a judge, which is going to, again, make it a more public proceeding, and there's going to be a cost involved. But if you feel that you've tried those two, you've documented, you've exhausted those options, everybody's looking the other way, nobody's doing the right thing, then you want to seek the guidance of an attorney who has the experience in doing this kind of petition. So in the last 2 years, we've had two new things available in Florida that I want to share with everybody. The first one is that in the designation of healthcare surrogate for an adult like you and I, we have two new options that we can offer to clients. And they have to do with timing. Timing being, when does the client want the surrogate to start acting for them? Do they want them to start right away once the document is signed? Or do they want the surrogate to act only when a doctor determines that your client can't give informed medical consent? So these are new language, new paragraphs that are put into the designation now. And the clients get to choose the timing of when the document is effective. And the clients also get to choose when will the surrogate have access to HIPAA information, confidential medical information. Do they want it now, or do they want it only when the doctor determines the patient lacks capacity? Now, if you have clients who have a surrogate designation that precedes the change in the law, the only way they can express these options would be to have their document updated. Another new creation in the law that I think is very timely is what's being called a designation of healthcare surrogate for a minor being somebody who is under age 18. So this new law was created because sometimes we have parents who are going on a trip, whether it be for business or for a vacation, and they're not taking the children with them. The children are being entrusted to perhaps a set of grandparents, maybe aunts and uncles, or somebody else that the parents trust. And if something happens while the parents are away, the child gets sick, the child needs a surgery, who can authorize that kind of treatment? So this is the response to that need that arose. So parents can designate who's going to be the surrogate for their minor age children when the parents are away or the parents cannot be reached. So it works as a temporary measure because when the parents return, the parents as natural guardians can automatically make their children's medical and healthcare decisions. But this works in that interim period. So I think this is a wonderful tool that we do need to share and tell clients about.
And you said these laws are new as of this year?
They're about 2 years old now, Liz. So there are.
I have a question.
Yes, Jill.
Which are you seeing, like in doing the timing piece, right? So normally we're used to where everybody has authority to act upon, execution of the document. So what are you seeing as more the trend? Are you seeing that people are more apt to stage this, where they're saying, okay, I don't want you acting in the immediate, but I'll allow you to, access healthcare information. And then at such and such time, I'm incapacitated, you now can act. What is that looking like now? Because people ask us all this and we need to be able to dialogue because we really move our clients to elder law attorneys, right? Because we inherit documents that make no sense or are 200 years old or whatever, whatever that looks like.
Okay, great question. Thank you for asking it, Jill. There is no trend. I can't tell you that I'm seeing something all the time. It really depends on the person. And that to me also depends on the age of the client and what the client is experiencing now, or have there been health issues in the past. So I have some clients who are at a stage in their life where they want to involve the surrogate. And so they choose to authorize the surrogate to begin making decisions now and have access to HIPAA information now. I've had some clients who say, no, I don't want them making decisions now, but I am going to give them the authority to have access to the HIPAA information, and then that way they can discuss it with me and they can kind of help me be that sounding board to make the right decision for me. And then I see people who say, no, the answer is no to either. I only want them to make the healthcare decisions and have the access to the HIP information when the doctor determines I lack capacity to give informed medical consent. So I see all different ways that people are approaching it. I think that to help you have the dialogue effectively with your clients, I know you're great care managers, so I know that you're going to get a history. And in asking about a history, you're going to ask if there are any former surgeries, diagnoses, immune system disorders. And I think also ask the clients about how did they deal with having to make those decisions? Was it scary for them? Did they feel they had enough medical guidance at that time? I think that'll tell you a lot about the person. And that will then help you share with them what these choices are that they can now include in their designation of healthcare surrogate document. Does that help, Jill? Okay, thank you. So I like to look at creating a plan for a client as being very comprehensive, that we're not just looking at medical, we're not just looking at financial in a vacuum, but we're looking at everything in a totality, because clients are, we are multidimensional, right? And so we need to look at all the factors that go into things. And that's why on this slide, I've listed some documents as part of a plan that deal with the financial side, even though today we're focusing on a discussion of medical advance directives. I do want to talk for a minute about the second one from the bottom, called the Declaration of Organ Donation. And I want to clarify that sometimes clients will say, oh yes, I decided to be an organ donor and I have that on my license. Is that enough? It is good that they have it on their license. But what this document does that's a little bit different is it allows the client to indicate, are they donating for transplantation purposes? Are they donating for medical research and study? You know, some clients that I see have had illnesses where they definitely feel, and I would agree with them, their organs are not going to be capable of being donated for transplantation. So they can choose to have it donated for medical research and study purposes. It also allows them to indicate, do they want the body returned? Or is the body going to be donated for scientific purposes? If they want the body returned, are they authorizing cremation, for example? So they can be very specific and very detailed in how they want their physical body treated when they leave the body. I've had some clients who, I don't know that I could necessarily tie it into their career and say that they were in the medical profession, but I think that there are certain clients that are very giving people and they see the benefit and the value, and they'll be very specific and also talk about that they want the skin donated because it might be able to help a burn victim, not just the organs. So this declaration gives the clients the opportunity to really think about and be clear about how they want their physical body to be used. The last document on the list, we call it a Declaration of Funeral Designee, is helpful for clients that, like we started this conversation, are afraid of talking about illness, death, and dying. And so we know that while they're alive, they are never going to make funeral arrangements. But this document allows them to name who they want to do that when they leave this earth. And it will say in the document, do they want to be buried? Do they want to be cremated? If they're going to be cremated, who should the authorized person give the cremains to? Is there going to be a service? Is there going to be a life celebration? And it allows them to think about these issues to the extent they're comfortable doing that, without forcing them to go actually make the arrangements. And I started doing this, I think I shared with Amy and Jill, probably about 15 years ago. I do a lot of work serving clients in the LGBT community. And back then, they really didn't have laws that protected their rights. So I thought about creating this document so that they would have somebody who would have the legal authority when they died to make and carry out funeral decisions rather than family members that they had been estranged from stepping in and taking over. But as time has gone by, I realized this is a tool that many people could benefit from. And so, as I said before, clients who are just afraid or might be superstitious that by making the funeral arrangements, it's going to hasten their death or their time of death, this has been a very helpful tool for them. So when I started this PowerPoint, I mentioned that I thought National Advance Directives Day was very timely given the COVID virus, and that my hope was that people would wake up and realize that there's no magic age at which facing these issues becomes important. And if you ever Google what the motor vehicle accident statistics are in Florida, you probably would not be surprised to see that the highest motor vehicles accidents happen in the 25 to about 27 age category. So even young adults, right after they're graduating high school, need advanced directives. I use this slide where you can probably recognize at least one person who's famous that you might identify with. And the shame is that a lot of people, especially people who have money, don't do the documents. They just don't. And it really is a shame. You know, Anna Nicole Smith had a very young baby when she OD'd. And a friend of mine who's a lawyer down in Miami was appointed by the court as the guardian ad litem for the baby to help the court make the determination of who should take care of her. It's very sad that people don't take the time or don't spend the money to think through these issues and then have the documents put in place, because there's no crystal ball. We certainly don't know when our time is going to be up and when we're going to get sick or when we're going to have that car accident. And so it really will save us and our family the privacy, the time, the confidentiality, just by having the documents. You know, Liz, a little while ago, you were talking about people who are millennials and what their view might be. For those of you that might not be sports fans, this is Lamar Odom, who played for the Lakers. And the woman in the photo with him is his former wife, Khloe Kardashian. Well, a couple of years ago, she filed for divorce. And before the divorce judgment had been signed off on by the judge, he was found in a brothel. He had OD'd on some drugs. He was taken to the emergency room of the nearest hospital. And because they were not divorced, she was contacted and she had the legal authority to make the medical decisions for him. Now, I had this discussion at that time with one of my networking groups, and most people's reaction was, oh my gosh, I would not want my soon-to-be ex-spouse making medical decisions for me. They might be motivated by the finances, especially because Lamar Odom was very successful. Now, not everybody will have that reaction. Some people might feel that if they've been in a very long trusted marriage, that would be the person they'd still want to make medical decisions for them. But I use this example because he was 35 at the time. Again, you would think that somebody who's famous, who has the money, would have documents, and he didn't. So If you find that you're working with a client who's in the process of a divorce, it's a great idea to mention to them that they shouldn't wait till the divorce is over to change or make new documents. Do it now. Don't take that time to, who knows what's going to happen. Here's somebody who was even younger. This is Selena Gomez, who started her career as a child actor on the Disney Channel. And at age 23, she was diagnosed with lupus, which is an immune deficiency disorder. So I like the fact that she came out and she shared this information publicly, because my hope was that parents of teenage children would realize that when their child turns 18, the child's an adult and the parent is no longer going to have legal ability to make medical decisions for that child. So again, we want to change people's consciousness. We want to change how they look at things and realize that at any age things could happen. It doesn't have to be a car accident. It doesn't have to be a school shooting. It could be a simple medical diagnosis that changes somebody's life forever. So now that we understand that there's no magic age at which somebody should make their or even update their medical advance directives, how does marital status impact medical advance directives? So if somebody's married, many times people will assume that their spouse could automatically make their healthcare decisions, and they don't need to put this in writing. Well, the answer is no, and we saw that in our discussion talking about a healthcare proxy. Yes, the spouse would be the appointed proxy, but what if there's a blended family? You know, we see a lot of second and third marriages these days. People really need to think about, do you want your current spouse to make your medical decisions? Or do you want an adult child from your former marriage? Or do you want neither? Do you want somebody else as your surrogate? What if you're single? Well, if you're single, even more so, you want to have that designation of healthcare surrogate in writing. You might choose your parents, you might choose your sibling, you might choose your best friend. It's up to you. You have a lot of choices, but you want to put it in writing. Here's a perfect example. This is our modern day blended family, Caitlyn Jenner with the Kardashian children and children from the prior marriage. You know, this is where it can get sticky, and it's important to choose the person or the people that the client feels are going to best serve, that are going to respect the client's preferences and follow through with that if the client can't communicate. So at any age, it could be the baby boomers, it could be Generation X, it can be the caregivers. And let's not forget about the caregivers, because whether you're the care manager or you're the elder law attorney, sometimes we become so focused on the individual that has the diagnosis, we forget about the caregiver. And they're the one person we really need to pay attention to, because they need the advance directives as well. We know from being in our respective professions that caregivers get burnt out. They focus solely on the patient's needs, that they put their needs aside, and they run down physically, mentally, and emotionally. So we want to make sure the caregivers have their medical advance directives in place as well. So I hope that you found the video we watched and this PowerPoint presentation empowering. I hope that you take at least one thing from today that you feel you can share with your clients, you can share with your colleagues, your families. And I'd like to open it up now to questions that you have, or concerns or stories you'd like to share. So please feel free to unmute your microphones.
One question I had was, if you are in a situation where the healthcare proxy, their decisions don't align, and you are told you need to go for a temporary emergency guardianship, and like the patient you were talking about that needed the invasive surgery, what happens in the interim? This person's, I just like picture them laying in a hospital bed awaiting to have surgery, but yet you have to wait on a document from the court to be able to do the surgery. So how does that work? Because sometimes it doesn't happen so fast, correct?
At times it takes not. Do you know what waiting communication? Okay, Jill, thank you. Okay, because now the interference is gone. So in the story I shared with everybody about the client's father who had the brain tumor and they got him into the hospital, he was stable while he was there. And it took us about 24 to 48 hours to do the paperwork, get into court, have the hearing, get the signed orders back. So he was fine. I think from a medical perspective, if the doctor or the surgeon deems that it is an emergency, they're going to, under their medical rules, they're going to provide the treatment. But this was not deemed an emergency. Okay, somebody else has another question. Feel free to unmute your microphone.
Is 48 hours typical, or you really had to push for that?
I can only answer it from my perspective, Liz. I can't say how do all attorneys do it, but I got 25 plus years doing guardianship experience. So we put everything else aside. When something like this comes up, we have to put everything else aside in the office, get the documents done quickly. If the client is local, we'll have the client come in to sign them. If the client is not local, we're going to email them and talk about them over the phone or through a video conference, and then get them e-filed. Now, things are better, they are quicker since we started electronic filing in the state of Florida, which goes back to 2012. So we very quickly get it into the court system, we get a judge assigned, and when we feel it's an emergency guardianship, we call the clerk's office and we ask them to even put it through faster. Okay, Jill, unmute your microphone.
So in a durable power of attorney, what seems like the most encouraging way to do authority is that everybody has independent authority to act, assuming there's a trust capacity in the family, and everybody's comfortable with everybody else's choices and decisions, or feels that they would bow to that person in the time of need. In a healthcare document, is it similar where you're giving independent authority to act, or you're listing one after the other? What do you see as the best way to do that, or is there a best way to do that?
Okay, no, great question. So what this raises is the importance of explaining to clients that they should not just think about having a primary surrogate, but they also need to have more than one alternate named. And the reason for the alternate is that something we could never predict or foresee could happen to the primary surrogate, and we need to have a backup plan. We need that plan B. There is no limit as to how many alternates can be named in a document. So I've had some clients list 3 or 4 alternates, and that's great. But they need to think about what's the order that they feel is best. And this goes back to, who does the client trust? Who have they had a relationship with where they've had conversations talking about, here are my medical views. Here is how my religious beliefs impact my medical views. This is what's important to me. This is what I'm afraid of. So they've had that confidence. They've shared those intimate types of feelings with this other person. Now, I think, Jill, what you're asking about is, what if the client wants to name multiple surrogates to act? simultaneously. I've always taken the view that both surrogates, co-surrogates, need to concur. They must agree. Otherwise, we really are creating a recipe for disaster. We're putting these two people in a position that if they, for whatever reason, can't work out their differences, can't agree, the doctor or the hospital or wherever the patient is going to say, forget the surrogate document, go to court.
Okay, but let's just say, so are we saying then that it says in the document that the two have to agree, or are we saying, okay, one is here, one, I'm making this up now, one is here, one is offshore, so the one who is here has the authority to act. How does that actually get executed?
That's interesting. So in your fact pattern, you're saying one surrogate is in the US and one is outside the US.
Let's say they both live in the US, only I'm traveling, to Italy, God willing, at some point, okay? And my brother's stateside, right? We have a 6-hour time difference. God forbid something happens and my brother has to make a determination for my mom or my dad. Does he need me to be involved and concur, or my brother could take the action?
Okay, so what I do in the way I write a designation of healthcare surrogate when we have multiple surrogates is it says concurrence of all surrogates is required. And then I would include language that if after reasonable attempts are made to communicate with one of the surrogates and they cannot be contacted and it's documented, then the other co-surrogate will make the decision.
Okay, so I'm not trying to be a pain in the neck on this, but we really do get this. So we have this to happen. So I want to understand that better. Like on a durable power of attorney, if it says, right, that you can't act unless, unless somebody is, first person has authority. Okay, first person can't be contacted or, can no longer act or whatever it is. Now we go to the second person. Okay, you've got to be able to prove up that that person can't be contacted or that person doesn't have the ability to act any longer. That's time. Sometimes there's a lag in time, and that makes for a problem. Okay, the same thing on the healthcare side. So what does that look like in real time in an actual example so that you don't have the lag in time in order for that person, right here, right now, to be able to make the decision and take authority?
My first suggestion is we can't compare the power of attorney to the healthcare surrogate. It's very different. Truly, we're never going to have the type of emergency in a financial situation as we're talking today about with medical situations. Also, because in a durable power of attorney, if multiple people have been named as co-powers of attorney, the client has to decide and the attorney has to put language in the document to indicate that either they're acting jointly, meaning they have to agree on everything, or they're able to act independently. And we really can't give that same kind of language in a healthcare surrogate to allow co-surrogates to act independently. From your question of what does the real time look like, I think every situation is going to be different. When the healthcare surrogate document is written, we want to put as much contact information as possible so people can be reached. That would be their cell phone number, their office number, if they have a landline at home, their email address. We want to make it as realistically possible to reach them within a reasonable period of time. Does that help, Jill? Okay, great. Aiden, I know you had taken your microphone off of mute. Did you have something you'd like to ask or add?
Yeah, one of the things I wanted to comment on was in very rare instances, I've come across some clients who have had a pre-need guardianship documentation. So does that apply in the event that a guardian would be needed?
That's a great question. including it. Will you mute your microphone? Thank you. So what Aiden is talking about is a different legal document. It's called a pre-need guardian declaration. And it's a way that an adult, somebody over 18, can put in writing, if I am ever incapacitated and somebody files for guardianship for me, this is the person, or these are the people that I want appointed to be guardian of my person and guardian over my finances. And under the law, this document is given a presumption that the judge should appoint these people unless there is a valid reason they would not qualify. So a valid reason would be that if the person named was convicted of a felony, they cannot be appointed a guardian in the state of Florida. Or if, let's say, somebody has a mental health condition that would prevent them from carrying out the duties and the responsibilities of a guardian, even though they were named in the document, then they may not be appointed by the judge. The nice thing about this document that Aiden's asking about is if a client thinks there's going to be arguing or disharmony going on in the family, this is done in addition to the durable power of attorney and in addition to the designation of healthcare surrogate. And again, I'll share a story with you. I shared with you that I do a lot of work in the LGBTQ community. This was another tool that I would use with those clients when they didn't have the rights that became available to them through the United States Supreme Court recent decisions in recent years. So their fear would be that they were coming to me, I was creating the legal plan, they had the power of attorney, they had the healthcare surrogate, it named their partner or it named their spouse. They might have gone to New York to get married because New York did same-sex marriages long before it became legal. And their fear was that the minute something happened to them and they became incapacitated, the parents or the siblings who didn't approve of their lifestyle were going to swoop in and file a guardianship. So this document became that backup plan. This was a way of, if we ever had to go to court, to show the judge that the same person they named in their plan was the person they would want appointed to be the guardian. Now, we don't have to just limit using it to clients who are LGBTQ. We can just use it for anybody. You know, if they're concerned that somebody in the family is going to be jealous because they weren't given a position in the power of attorney document or the healthcare surrogate, and they're going to get jealous and try to make trouble by filing for a guardianship, this is a tool that can be used.
So wouldn't it make sense to name different individuals for your pre-need guardian than you would for your power of attorney and healthcare surrogate?
Tell me more. I'm not sure I know why you're thinking.
We have a client right now. I'm actually in the process of doing her documents with her, and she has named her two daughters, one of them first for power of attorney, and they're both power of attorney and they're both healthcare surrogate. There's a lot of unrest between the two of them, and but her pre-need guardians are also her daughters.
Oh, okay. So that is a little bit different. In your client's fact pattern, she is anticipating that the daughters are not going to get along. So yes, I would agree with you for that particular client. The suggestion would be to name a third party, somebody who's neutral, that she feels she can trust to carry out her preferences, name that person in the pre-need guardian declaration.
Okay. Otherwise, I feel like she'll just run into the same issues.
Could be. That was a great question, Aiden. Thank you for bringing that up.
Thank you.
Erin, do you have any questions? Anything you'd like to share?
No, not really.
Well,
Stephanie, I have another question.
okay.
You had mentioned that social workers can be named as surrogates. We've been named as a company. Like I've worked with attorneys where the attorney will come to me or I will offer it as an opportunity and say, okay, listen, Advocare can step in when somebody doesn't have anybody, right? Advocare can step in. And the way we view that is that we have registered nurses on the clinical team. So we don't have the attorney name the individual nurse. We'll name the company Advocare. And then, let's say to be determined at time of need. Because what happens if that care manager, let's say, is no longer? There are lawyers who have attempted to name me in guardianships where I'm named into the document, and we try to avoid that just for the same reasons I'm telling you now. So what's your position on that?
All right. Jill, would you mute your mic, please? Thank
Yeah.
you. So I think that's fine, naming the company, the care management company, in the designation of healthcare surrogate document. I also recommend that you meet with the individual like you normally would with a private client, care management client. You do your intake, you do your history, and you take the time to explain to the client, here's how the services work. We're going to have a written contract so that you and we agree what our services as the healthcare surrogate would be charged at and who would be responsible for paying the bill. Now, some care managers I have worked with over the years who agree to serve as a surrogate like to also establish with their client that in the beginning, when they don't need to act as the surrogate, they might, for example, be communicating once a month with the client. Or maybe the client and the care manager agree to do a bi-monthly or a quarterly. So the client understands you're going to touch base with the client. The client understands they need to inform you if anything changes, even if it's a change in a prescription. They changed a doctor, but they need to keep you updated and that they will get an invoice for those monthly, bi-monthly, or quarterly communications. Well, everybody had great questions today. I'm really glad that we did this webinar together. I'm going to shut off the recording in just a minute, and then I will send an email to everybody with a link of the recording so that if you want to refer to it in the future, you'll have that as a resource. Thank you.
Stephanie, this was great. Thank you for doing it.
This conference will now be recorded.
Really good.